Um, my name is Kasper Zajac. I'm currently a postdoc at Wageningen University in the Netherlands, working as part of the Rebalance project on the issue of corporations and the rule of law. And this is our third talk in the series, and it's on the subject of horizontal effect of the rule of law in the practice of the European Court of Human Rights. The next one, if I may remind everyone, will be about corporate actors under the sanctions regime, and will take place this week on Thursday. Obviously, everyone is invited. A bit of housekeeping first. There are two language channels for this event, English and Ukrainian. You can select one based on your language preference. We have very capable interpreters with us today. Each speaker will have around 4 minutes to respond to the question, and we will do our best to also take questions from the audience, if there are any, in between the rounds. Now, if everyone is ready, I would like to introduce our distinguished speakers. And first, I will start with Robert Spano, that is the former president of the European Court of Human Rights. And if I may say, in that capacity, also former boss of my boss, that is Judge Bosniak. Judge Spano is currently a partner in the London office of Gibson, Dunn and Crutcher, as well as a visiting professor of law at the University of Oxford and a professor of law at the University of Iceland. Next, we have Pavlo Puškar, head of division at the Department for the Execution of Judgments of the European Court of Human Rights, of the Directorate General of Human Rights and the Rule of Law at the Council of Europe. Then Danielle Ann Pamplona, a full professor at the law school at the Pontifical Catholic University of Paraná in Brazil. And then finally, Stanislav Pogrebniak, a chair of the Human Rights and Legal Methodology Department and the Yaroslav Mudry National Law University in Kharkiv. Now, if everyone is ready, please confirm, and we will start with the questions. I see no opposition, so let's start with first round. And the question is it commonplace to talk? It is commonplace to talk about horizontal effect of human rights, but could or should we talk about horizontal effect of the rule of the rule of law? And at the same time, is the rule of law a state-made order, that is public order, or should it be combined with self-regulation by companies? And if I may, I would like to direct this question first at Judge Spano.
Thank you very much, Kasper. First of all, very happy to be with all of you here this morning. Once again, as I said the last time I was invited by Elena, thank you very much for inviting me to take part during a difficult time for your country. It's always a pleasure to be able to continue a conversation in times where conversation is so needed. As to your question, my view is quite clear. The rule of law is not limited to the vertical relationship between the individual and the state. The rule of law is a requirement for any individual and legal person, as we're talking about corporate actors, to be able to regulate their behavior in accordance with the law. So that means that even in private-to-private horizontal relationships, there needs to be transparency, there needs to be foreseeability, there needs to be clear legal norms that guide the behavior and the balance of interests that often come into play when private-to-private relationship may impact human rights. I think one example, probably in my view, one of the best examples in recent case law of the European Court of Human Rights is the Grand Chamber judgment in a case called Barbulescu versus Romania. So this is a case about an employee in a private company whose email correspondence was monitored. So what do we have there? We have a private-to-private relationship. We have the right to private life of a private employee, which is engaged by monitoring activities of a private employer. So therefore, the question arose in this case, to what extent does the state, which is the defendant, always the defendant in the European Court of Human Rights, you cannot complain to the court against private actions. to what extent does the state have an obligation to adequately regulate from a rule of law perspective the horizontal relationship between a private individual and a private company? And the court, under the general principles of positive obligations of states, made clear that in that context, a state has to establish a legislative framework, a rule of law criteria, a rule of law condition, to adequately safeguard the balance of interests between the private employee and the private company, the employer. And in this case, the state, through its national courts, had not been in a position to adequately safeguard that relationship. So my answer to the first question, or the first limb of the first question, is absolutely yes. The rule of law principle is fully applicable in private horizontal relationships. As to the second point, very briefly, because I only have 4 minutes, my view is it depends. It depends on whether in a horizontal relationship, especially with corporate actors, the rule of law orientation, the rule of law principle goes to some extent hand in hand as things stand, in particular in the tech space, digital rights, ESG spaces, very much hand in hand with an initial self-regulatory environment. Let me explain this. So the European Union is very much engaged in ESG, business and human rights type legislation now, as you will all know, triggered by climate change, the revolution of business and human rights principles in the ESG space, both when it comes to reporting obligations under the CSRD, and now in the future, the CSDDD, and along with AI systems in private relationships is becoming a huge issue. And there the EU is taking the approach, the companies should also risk assess, they should internally present or perform a risk assessment of their adverse human rights impacts, subsequent to potential public or private enforcement, which would be by a regulator or by private users, consumers. So it is a system of the rule of law within the horizontal context, which is both based on internal risk assessment by the companies, but that forms the basis of potential openness to liability.
Thank you for this answer, Judge Spano. Next, I will ask Mr. Pushkar.
Yeah, thank you so much for this question, and once again, thank you for the invitation to take part in this event. Of course, one can answer the first question very positively in brief without going into much of the details, but I guess this is not the case that we have to follow. So I think obviously we cannot avoid speaking about the rule of law as a concept stemming from the statutory framework of the Council of Europe. I will speak a little bit in the first place about the Council of Europe and the statute itself, as well as the convention. They refer to the rule of law principle as the part of the heritage of the Council of Europe member states. And obviously, if you look at this heritage on horizontal level, the non-compliance with the rule of law principle in relations between the states might lead also to expulsion of a state from the Council of Europe, which has happened in the situation of Russia. So I think there are several kind of different probably versions of understanding horizontal effect of the rule of law, not only probably in relations between private parties and individuals, but also kind of horizontal effect in relations between the states. And I think that's one of the visions of the rule of law that I would like to suggest, and probably will follow on that a little bit from the point of view also of the problem of reparations that are to be offered for the war of aggression, and relations of reparations to the remedies that have to be provided and their enforcement also through private actors. So in this sense, this horizontal relation of rule of law can be seen in this sense in relations between the states, but also the prominence of the rule of law in international law as such, as the core principle and foundation of rules-based international order. But if we speak more precisely as regards the case law of the court, I think the rule of law component can be seen also as a methodology of evaluation of compliance with obligations under the convention. So it can be seen as a part of discussions on various rights, and we can see rule of law discussions in assessing compliance with obligations to investigate, for instance, torture or death of persons, also of private individuals, in relations between private individuals on one hand. We can also see the prominence of the rule of law principle in enforcing itself in relations of detention by private individuals, and there are cases in relation to that. But also, Professor Spano already mentioned the qualified rights and the right to privacy. And I think the main prominence in the case law is occupied actually by the right to privacy as such. And already the first case concerning Ukraine, the case of Sovtransavto, is a vivid example of the relations between private individuals, and probably the highest level of appreciation or assessment of rule of law principle compliance in Ukraine is the case of a group of cases of Zhovner, Ivanov, Burmich, where the issue of rule of law is seen from the perspective of enforcement of rights, also on behalf of the state with a view to ensuring these rights for private individuals. So I think from this sense, we can see also horizontal effect of the rule of law as sort of in assessment of rights horizontally, yeah, and as a methodology. And if we look at the Ukrainian case law, there are probably 200 judgments or more than 200 cases where the rule of law principle is referred to. And probably the next one would be the horizontal effect as it is seen by the Venice Commission rule of law checklist, which is also an extremely important document in situation of Ukraine as well. There are vivid discussions as to the notion of the rule of law in Ukrainian academia, the translation of the rule of law, верховенство права, правовладдя, what is more powerful, explaining actually the notion of the rule of law. But indeed, I think the rule of law checklist largely refers to this horizontal effect of rights and the principle of Drittwirkung effect, which is a very important principle to ensure also erga omnes effect of the case law of the court itself. And you can find a number of cases where this effect is being shown. For instance, the case of Mutu and Pechstein versus Switzerland, which relates to the fair trial rights in arbitration proceedings under the Private International Law Act in Switzerland. And that's actually a very interesting aspect, because there is a waiver of rights on the one hand, and on the other hand, there is an imposition on essentially private arbitration proceedings of the principles stemming from Article 6 of the Convention and the right to a public hearing. I already spoke about the Article 5 cases. There is quite a vast jurisprudence on enforcement of private and horizontal effect of rights under Article 5 and the right to liberty and security of a person. But I think it's mostly related to this ensuring positive obligations of the states. So that's how also the Venice Commission checklist sees it. And finally, there is this discussion, I think, in Ukrainian academia as to seeing horizontal effect not only related to a layer of domestic rule of law, but also probably I started from that relating to actually horizontal or vertical effect of rule of law in relations between international and domestic law, depending on how you see this relation. Either it's dualistic, monistic, you see it vertical, horizontal, you see it as kind of coherent relations between the two legal systems. I mean, the connotation also between the private and public international law is seen as less obvious as well in this sense, because the common principles of the rule of law, like principle of res judicata, for instance, they are applicable to both systems. And for such principles, the difference between the principles of rule of law is actually evaporating in the academic discussions. So I think that's kind of a conclusion that I wanted to make, because in a sense, to this very complicated question, which could be seen as having a very simple answer, but I think it's a very kind of inclusive principle. On the one hand, it's a methodology that is used by the court, and it's a process of defining the obligations that helps to define the obligations in a situation of their breach, especially. But it's also a very important source and principle of international law as such. One can argue that, and I think it's a principle and the source of international law that can be extensively discussed at a number of levels as being a very complex principle as well.
Thank you for your insight. Now I direct the same question to Ms. Pamplona.
Thank you. First, let me thank for the invitation to be here today among these distinguished panelists. I'm very honored to be given the chance to discuss the theme that is being presented. And regarding to your question, let me start by saying that I believe we not only can, but we also should extend the rule of law to private entities. But my first reaction to the question is that the rule of law was conceived as a limitation on states to guarantee individuals' freedoms and also to guarantee their sphere of autonomy, the sphere in which they can make decisions without depending or needing authorization from the state. So it arises, the rule of law arises to regulate the conduct of the state and of course, to keep it in line with the legal provisions in the spirit of protecting the citizen against the excesses of those who exercise state power. So for me, this is really a citizen's defensive right. And it follows from the rule of law, the legality principle that for private parties means that where the law does not prohibit, there has always been freedom to act. So I do make a distinction between the rule of law and the principle of legality. It derives from it. And if it derives, it has always meant something different when we apply the principle of legality for state and for private entities. And this is why I feel that it's relevant to extend the rule of law to private parties, because this structure was created to limit the state, of course, because it was too powerful. And it was invading a sphere that should be a sphere of people's autonomy. With this in mind, and given the power of some private entities, which we also do not discuss, I think it's an interesting idea to extend this courtesy of limiting the power of some of these entities for the same reasons. And this is where I want to depart, because this will amount to giving the rule of law a horizontal effect. So for instance, and of course, I'm speaking from Brazil, and for me, the Latin American system is the system that relates to the question. So the protection of human rights here made by this Latin American system cannot actually be decided on the actions of private entities, because only the states can be a part of these cases. But it doesn't mean that it will not be possible to discuss the horizontal effect of the rule of law even here. I think that I should point out that it has become increasingly common to recognize, for the system to recognize that rights are violated because of actions of private entities. And then it follows from that the duty for the state to be diligent and to protect human rights. So I would say that some of the states have been called into action by the system because it did not prevent the conduct of a private entity when it could have done so. So this has been happening since the 90s, and of course with the ESK rights in the 2000s, when these cases became to get to the court, it has been more revealing of the effect. So I would say that in short, I believe that we can talk about the horizontal effect of the rule of law, and we should do that. But having in mind that since it was created to limit power there in the 18th century, the power then was a power that people faced and came from an authoritarian state. And nowadays we have a similar situation, but a power that threatens people's rights does not emanate only from states anymore. So it seems to me that extending the rule of law to private relations, it's clever, and it's also an adequate way to tame the corporate power. I would say that this is the distinction between rule of law and legality principle. It's key to make it work, because legality has always been there. We have not denied that even private entities should follow legislation. But the thing is, what about caring for the elements of rule of law? What about private entities caring for democracy, caring for human rights? And this is where I'll go a step back, find why we created rule of law in the first instance, and then apply it to private entities. Thanks for the question.
That's certainly an interesting take. Thank you. And now finally, Mr. Pogrebniak. Is Mr. Pogrebniak with us? I saw on the list of participants that he was online.
Все, дякую. Пробачте, звук не включив. Дякую, перш за все, за можливість виступити на такому поважному заході.
Partake in such a distinguished event. I've got lots of the answers to questions which you have posed. Generally, I would like to agree with the majority of the statements made by the speakers. However, I have several compliments to the material.
Чи можливий горизонтальний ефект в сфері верховенства права та в сфері прав людини, то мені здається, що незважаючи на усі ті теоретичні, особливо філософські проблеми, які виникають в цій сфері, тим не менш ми повинні дати, мабуть, однозначно позитивну відповідь на це питання, враховуючи, що, я б вважав, керувався б тут таким міркуванням, що як права людини, так і верховенство права є беззаперечними конституційними цінностями, складовими нашого конституційного ладу, який проголошений першим розділом Конституції України. Вони, безперечно, мають імперативний характер. І тому мені було дуже важко уявити собі, що ж це за таке верховенство права, яке б діяло лише в вертикальних відносинах. Бо панування права, або, скажімо так, сприйняття права як регулятора суспільних відносин не може стосуватися лише вертикального виміру. І що це має стосуватися також і горизонтального виміру. Окрім того, виникає знову ж таки питання про те, а яким би чином ми могли забезпечити права людини, які мають, деякі з яких мають абсолютний характер від порушень і від захисту їх у горизонтальних відносинах. Тому мені здається, що верховенство права і права людини можуть мати горизонтальну дію. Якщо говорити про друге питання, то тут дійсно можливо звернутися до досвіду Європейського Союзу, там, де, по меншій мірі, сформульовано 3 можливих рівні горизонтальності, по горизонтального ефекту. Про 2 з них вже сьогодні говорилося. Це дія через опосередкований державний ефект через позитивні зобов'язання, коли зобов'язання між сторонами формально покладені на державу, яка має створити для цього відповідні законодавчі можливості. І крім того, звичайно, що створення подібних можливостей державою відкриває нам і другий рівень горизонтальності, а саме покладання прямих зобов'язань щодо прав людини на приватні сторони, так званий прямий ефект варіант горизонтального ефекту. От. Крім того, ми можемо згадати і про третій напрям, про непряме застосування фундаментальних прав до міжіндивідуальних спорів шляхом судового тлумачення, так званий опосередкований ефект, який ми сьогодні, скажімо так, не обговорювали, але який теж є перспективним з точки зору, наприклад, діяльності Конституційного суду, який може інтерпретувати певні положення саме через теж врахування цього горизонтального ефекту. Щодо третього питання про те, чи повинна бути ця належна обачність, мені здається, що така належна обачність з боку бізнесу має бути, і більш того, мабуть, можна говорити не лише про належну обачність, але, можливо, про належні очікування, які є у суспільства від бізнесу. І в цьому плані можна згадати відомі ідеї про те, що, скажімо так, повага і втілення в життя і прав людини є складовою, так скажімо, образно є складовою так званої соціальної ліцензії на діяльність. І вона теж чудово вписується в концепцію корпоративної соціальної відповідальності бізнесу, про яку ми також маємо згадувати, коли говоримо про перспективи впровадження ідеї горизонтальної дії прав людини і верховенства права. Тут це те основне, що я хотів сказати з цих трьох питань.
Дуже дякую. Я знаю, що у пана Спано є деякі домовленості, то він має нас полишити раніше. Тому перейдемо до третього питання, щоб відпустити його раніше. Тож надамо пану Роберту слово зараз, а на друге питання у нас головним доповідачем буде пані Памплона. Отже,
It should be actually part of the horizontal effect of the human rights. Thank you.
Background is important here. I think it's good to start with some dates, or let's say years. So year 2000, the United Nations began its history of sustainability with the UN Global Compact, which was then presided by Secretary General Kofi Annan. This was a very interesting process, which culminated in the UN sustainability goals, which we all are aware of. Subsequently, interestingly, in 2006, a group of global financial institutions published a report on sort of ESG requirements in investment opportunities, the way in which investment should be analyzed from an ESG perspective. And actually, the concept of ESG started to materialize for the first time in their report called Who Cares Wins, which is a very important part of this process. But it's actually 2011, which is one of the most important years, because then the United Nations adopted the UN Guiding Principles on Business and Human Rights under Professor John Brugge. Subsequent to that, in 2015, of course, climate change becomes a very important part of the multilateral narrative and debate with the Paris Climate Accords. And then subsequent to that, or during that period, we start to see the European Union begin its process of ESG regulation, first step being the requirement that companies report on their ESG journey. So in other words, assess their risks to sustainability, which is usually called impact or sort of inside or internal materiality. And then subsequent to that, now we're seeing the move towards, you were mentioning, Kasper, the move towards reporting into due diligence. So companies are having to perform more due diligence on their operations and chain of activities vis-a-vis human rights. So where are we now in this process? And coming to your question, I think on the one hand, we have, in the European context, we have already seen a number of member states to the European Union, France in 2017 with the vigilance law, the Loi de Vigilance. We have states like Germany, which have also enacted human rights due diligence laws. Norway, outside the European Union, but within the EEA, has done the same. And now, of course, the EU is in the process of adopting the CSDDD, which is the Corporate Sustainability Due Diligence Directive, which is a fundamental due diligence directive which will have profound impacts on the way in which business behavior and business models will be transformed moving forward. So to come to your question, I think we do not as yet have consensus when it comes at the European level. I would not want to go so far. I would want to be more prudent to say that there is consensus, because the Corporate Sustainability Due Diligence Directive is still undergoing some negotiations when it comes to some of the salient elements of that directive. But there will be a finding, there will be a conclusion found when it comes to what would be the fundamental elements of corporate sustainability due diligence, human rights due diligence by states. And that, I think, will definitely have an impact on the way in which this environment will develop moving forward. So I think from a European perspective, and remember, human rights due diligence is very much now in globally a European concept. The US does not have, if for those of you that have any knowledge of the Securities and Exchange Commission, the SEC requirements in the US, they do not require impact materiality assessments or due diligence assessments. Of course, I'd very much like to hear from Daniela when it comes to the Latin American system. Of course, due to the influence of the Inter-American Court of Human Rights, there is, of course, very much a sense of, although it's, of course, mainly vertical, the idea we see with national courts dealing with climate change disputes. We have famous cases in Ecuador and in other areas where companies, especially fossil fuel companies, have been engaged in liability regimes based on their adverse human rights impacts. But in Europe has taken the lead when it comes to business and human rights developments in hard law, because remember, this has been mainly voluntary soft law principles, the UN guiding principles or soft law, but we're now moving into a more mandatory system of human rights due diligence, both at the EU level and at the national level. I think this is a train moving forward which will not be derailed. I think it is clear that, in particular, the political prerogatives of climate change will result in these rules becoming very prevalent for businesses in the European landscape. And when I say business in the European landscape, it is also businesses with a multinational footprint, which do not necessarily have only establishment in the EU, but they are established in the US, but have subsidiaries in the EU, and so forth. Finally, I think we will also see the destabilization of the European sphere. We have the aggressive war in Ukraine. We have issues happening now, terrible things happening in the Middle East. All of this will trigger increased reliance on the corporate environment being a part of the solution. I think it's not sustainable for the future due to the immense footprint and influence of businesses to think that they can be sustainable in their business models without being an integral part of a potential future solution when it comes to the way in which European societies will deal with the fallout of these crises that we're seeing. So that's sort of in broad my answer to that question, Casper.
Thank you very much. You mentioned Professor Pamplona, so perhaps maybe we go directly to her, if she could shed some light on that issue.
Yes, thank you so much. Well, to react to what Mr. Spano was saying, I will share that the Inter-American Court has been indicating more and more that there is a responsibility of corporations to adopt measures of prevention. But of course, it does also say that the states are the one who has a duty not only to be diligent, which has been international law since ever, but a duty to adopt the measures that will make the corporations to adopt the preventive measures. And the national courts, in regard of the environmental cases, they have been applying the precautionary principle. And from this principle, they derive the obligation, and there, yes, we're talking about a duty for corporations to be diligent. But this diligence, it's not exactly the same one as structured either by the United Nations guiding principles or even by the OECD guidelines. It's a diligence that it's a bit different. It's not as structured as they are in these documents, but still, at least we do recognize in national systems, in national courts, the obligation of corporations to do something regarding prevention. And also, I should add that we do not have national legislations that will talk about human rights due diligence as we see in other countries, and mainly as in Europe, as Mr. Spano was mentioning. But I would like to also add that I believe that we can talk about a desire to build consensus, mainly within the development of the CS3G that Mr. Spano was mentioning, and that will be clearer as the national legal systems in Europe start to create their own legislations, their own regulation. But I want to take again a step back and think about the concept. When we discuss the horizontal effect, it applies to human rights. It's about applying to private individuals the obligations to respect and protect that are normally opposed to states. So if we conclude that there is a consensus on the application of the human rights due diligence, and I'm not sure, I would have to reflect deeper on that, whether this consensus transforms the human rights due diligence into a human right. Or if we are in fact talking about a consensus on the use of a procedure that seems to guarantee that human rights are not violated. Because this is not the same. It's not the same as saying that there is a consensus about the procedure itself or about the human rights due diligence as a human rights. And I say that because there is no certainty of the effectiveness of the human rights due diligence, at least in the way that it's been created so far. We don't have the distance in time to assert that. So it's not possible to say whether it will become something qualitatively effective in the near future. I think that this is why we need to reflect on what exactly we want to be the content of the human rights that we wish to see applicable horizontally. Is that the human rights due diligence itself, or is it more about a procedure that guarantees human rights protection? So having said that, I myself want to live to see companies adopting preventive measures. So of course, the ideal will be to be able to stop the occurrence of rights violations, but my concern is to actually lay a very solid foundation for this, which is why I think that this question leads to important reflections on the need to reinforce the idea that human rights deserve prevention rather than mitigation. But this is, of course, another discussion. But this could also be an important key to enabling this encounter between human rights due diligence and the horizontal effect of human rights? Thank you.
Thank you for this answer. I see we have a question to Judge Spano on this very issue. So maybe before we move to our remaining speakers, I would like to direct that question to Judge Spano before he has to go. And the question is, are there any European Court of Human Rights decisions regarding responsible business conduct, or at least some implications for the court's use of this concept in its case law? Judge Spano?
We don't have at present, and I did some research to be clear on that, we don't have at present case law of the European Court of Human Rights, for example, which refers directly to the UN guiding principles on business and human rights, unless I'm mistaken. That's at least my research up until now. So one cannot say that the case law is directly relevant for the development. But I would say, however, that when we look at some of the case law also mentioned by Pavlo, case law, for example, in the environmental sphere, so I take a different approach, issues related to questions of imminent environmental harm, pollution, even construction and earthquake readiness, and so forth. Cases related to, we have some cases related to safety requirements in tourism, for example. All of this, remember, under the case law is viewed through the prism of the state's positive obligation, because businesses, again, cannot be defendants before the court. But in those cases, one can see that it is one of the state's obligations to impose on businesses through national laws requirements for responsible business conduct. So that's the way the non-state actor liability and responsibility regime is viewed through the European Convention on Human Rights, vis-a-vis the positive obligations of states. And of course, if one looks at the case law through that lens, there is, of course, a myriad of examples of the requirement, both under Article 3, Article 8, even other provisions, which would be which one could classify as cases which have an impact on responsible business conduct. Now, there are, of course, myriad ways to conceptually classify those types of cases. But as yet, the evolution of that case law has not been, and maybe the academics in the room will correct me if I'm wrong, but I haven't seen as yet a direct reference to the Ruggie principles, even the OECD guiding principles on multinational enterprises. But I would not be surprised that we will see more of them, more of these principles coming into play as applicants and governments rely on them, to be able to increase on the claimant side or mitigate on the government side the obligations which flow on the state to have an impact on responsible business conduct.
Thank you for your answer. And next, I will ask Mr. Pushkar to address this issue, but I also see that my colleague has a specific question regarding this issue directed at Mr. Pushkar. So perhaps maybe I could read the question and you could address the issue generally, but also engage with the specific question. And the question is, whether the European consensus could be recognized in the European Court of Human Rights case law based on the changes in the regulation in the EU countries. And this way, all the Council of Europe members will need to implement corporate sustainability due diligence approach. So as far as I understand, is that a viable approach to this issue? Mr. Pushkar?
Yeah, I think the way the consensus is formed in the ECtHR case law is a very complicated topic as such, and the way it's traced to being formed as well. it's a separate topic which will require rather extensive discussion. But I would say that the likelihood of consensus being based solely on EU directives or on EU regulations is not necessarily is not necessarily resulting in establishment of consensus. So it could actually lead to forming some sort of agreement that there is a need to move forward with an issue, but then I think this would need probably to be more focused on the work of the Council of Europe itself. So probably some form of standard setting within the Council of Europe would be still required, and some initiatives to form this consensus. Usually it's consensus which is formed as a part of discussions before the Committee of Ministers of the Council of Europe, and the degree of innovation is also appearing there. But I think these are kind of different topics. The forming of consensus or establishment of whether there is consensus in the EU, in the ECtHR member states through EU kind of regulations, that's one thing. That's how the court kind of defines it in its own process, but also separately the Council of Europe, how it would develop a standard, a common standard for everyone. And I think we are kind of a bit away from both in both instances. But if EU would consolidate its vision on the issue, I think it would be much easier to move forward, of course. That's definitely definitely how it works in other situations. I don't know whether I should continue with the second question, or what would you prefer, Kasper?
If you can briefly address this question, yes, provided you can do it relatively briefly. Thank you.
The second question, or we are returning back to the second question, or the third? No, just to.
I'm sorry, the third question. Before we move to the second question, if you have anything more to add regarding the third question, relatively briefly, please do. If not, then we can move to
I would prefer
Mr. Pogrebniak.
Quite a number of things were already said, so I think it's fine.
Thank you very much. Then finally, in the context of the third question, so again, the European consensus, if Mr. Pogrebniak would like to add anything to the discussion.
Thank you. So, in terms of the European consensus, I can say that, unfortunately, as of now, we cannot definitely state that it does exist. On the one hand, it's not a surprise, given that consensus is formed on the general background. We know that there is no global consensus, and even within Europe, there are states with their own, sometimes contradicting views. So some of them do not hurry, do not make haste in this respect. However, I'm optimistic. I can say that throughout the past 20 years, a great progress has been achieved compared to the previous eras. Maybe there was some catalyst, such as a common policy developed for the European Union. This common policy can stimulate us as well to the European consensus. I have read some studies, some papers, and actually, there the authors stated that there is no consensus at the moment, and the definition of the problems is quite an issue. Nonetheless, the progress is evident. We can trace it, and I'm sure that such progress will persist.
Thank you, Mr. Pogrebniak. Now moving to the last question is, could we say that what is the impact of the business and human rights development on the inter-American system of protection of human rights? Could it be useful for other regional systems? And I think this question we will direct primarily at Professor Pamplona, but I know Judge Spano has to abandon us quite quickly, so maybe before he goes, he would like to add something to that question, naturally from the perspective of the European system. And then we move to Professor Pamplona. Thank you.
Thank you once again. Indeed, I think you know the classical approach of the European Court of Human Rights is indeed to be open to being influenced by the way in which jurisprudence, both nationally in Europe, but also by other international quasi-regional courts, develops. The European Court of Human Rights has often referred to the case law of the Inter-American Court, as Professor Pamplona knows probably very well. And I do think in particular, if we look at the way in which, I just want to take one area, which is also a business and human rights area, which is the issue of climate change. The way in which the national courts in Europe are dealing with that issue from the perspective of state liability, but also the way in which we see that develop in private litigation. For example, litigation by NGOs and others against fossil fuel companies like Shell and others. These are cases percolating in the national judicial systems, I do believe will have an impact and are already having an impact on the way in which the case law of the European Court of Human Rights will develop, and vice versa, of course. I mean, we already have 3 climate change cases, as you know, pending before the Grand Chamber of the European Court of Human Rights. And it seems clear to me that the outcomes of those cases will have an impact on the way in which these issues will develop at national level and potentially also in other regions of the world. So again, international law and the convention never operates in a vacuum. It is always a part of a juxtaposition of norms back and forth in the global sphere. Now, of course, there may be certain regional specificities. And for example, I'm sure Professor Pamplona will talk about some regional specificities in the Latin American system, which have created sort of a very robust jurisprudence on behalf of the by the Inter-American Court in areas which we would not necessarily see in the European sphere. So bottom line, the answer is, I think, absolutely yes. This is not a system which is closed. It's a system which is open to developments and influences, and it will certainly be moving forward like that. I just want to use the opportunity, because I will leave you now, to thank Professor Uvarova for inviting me again. I'm very happy to see all of you, my friend Pavlo Pushkar, and you as well. So thank you very much for having me here today, and I wish you the best in your upcoming conferences. Thank you.
Thank you, Judge
Thank
Spano.
you. Thank you very much.
I think on behalf of everyone, I can safely say that we have all benefited immensely from your insights. Thank you for taking the time, and have a great rest of the day. Thank you, Judge Spano.
Thank you very much, Kasper.
And I will now direct the question to Professor Pamplona. Please take your time. This question is specifically regarding the Inter-American system of human rights protection, and I think your contribution will be first and foremost most important. Thank you.
Thank you. Thank you so much for the question. Let me start by saying that I totally agree with Mr. Spano's words about the plasticity of the regional systems. And of course, there are things that we take from other systems as the European system, as well as from the global system, and as the European has been taking from the Inter-American system. So it's important to note that the Inter-American system as a whole, it has absorbed developments in business and human rights. And it's important to notice that it is not done from the top down, but rather it springs from the need that has been expressed in the cases that have come before the court, and cases that deal with violations of human rights directly caused by private parties. So whenever the court is condemning the states for failing to protect those rights, it ends up recognizing the role of private entities in causing violations to occur. So this recognition led to the inclusion in our special rapporteur for economic, social, and cultural rights. So it led to the inclusion on their mandate, in its mandate, of the competence to deal with the issue of corporations and human rights. And one of the most important developments I think we have to share is the report that was presented by this special rapporteur in 2019, which is entitled the Inter-American Standards on Business and Human Rights. And this report is based on the guiding principles on business and human rights. And it's not limited to Pillar 1, as one might think, because we're talking about a system that does not talk directly to corporations. So besides that, it talks about Pillar 1, of course, to reinforce the obligation of states to protect human rights, but it also deals with issues under Pillar 2 of the guiding principles, which relates to the responsibility of corporations to respect human rights, mainly using the same language, the human rights due diligence language. So this report, it takes a look at what has already been developed in the region, in all the other cases that we've been discussing, mainly environmental rights. And it establishes that when we are dealing with business and human rights, with this relation between economic activities and human rights, it is necessary to have as a backdrop elements that have been developed by the system over the years. So it calls them the fundamental inter-American criteria for the business and human rights. And there are 10 of them. And I'm just going to mention, for instance, the centrality of the person and dignity. This is relevant, and it's being developed by the case law in the inter-American system. And it actually is able to inform decisions when there is an opposition between development and the protection of ask rights, which is an issue of the most importance in the region, because we're always opposing the right to development and what is its content with the rights to the other, to the social and cultural and economic rights. Or for instance, the right to defend human rights or the right to a healthy environment, which has been developed in the region way before it's being talked about in the global system. So I guess that while it is clear that inter-American especially the court's functions are focused on state conduct, and that it only has competence to determine the responsibility of states for possible human rights violations, we can also say that the system recognized that by interpreting the content and the scope of the human rights that are recognized in the relevant documents, the relevant instruments in the region, together with the respective obligation of the states, the court can derive correlative legal effects that actually will bind corporations in this area. This is why the report also clarifies that it is an inter-American criterion to prevent and to adopt due diligence procedures, and also transparency and access to information, which are very relevant to our region, mainly when we face the human rights defenders' challenges in the region. So I believe that this is an important development because the system is indicating to the states what they should demand from corporations in order to avoid a condemnation in the system. And this idea is not only on the report, it's being reinforced in cases, for instance, the case Calinha Ilocono versus Suriname in 2015. The court was already indicating there that first, there was another entity that was not the state involved in the violations. Second, it also indicated that there was an omission on the part of the state, either to prevent or to avoid those violations. And third, it also indicated that corporations should also act with diligence, and making the difference between what is the diligence of the state that was already presented in the international human rights law with the diligence of corporations. So this is the responsibility of companies to act in accordance with the respect and protection of human rights, which is a duty to respect the rule of law. So I think that as the different regional systems can see the developments from one another, as Mr. Spano was mentioning, for instance, the forced disappearance case law borrowed from the Inter-American system into the European system, I feel that the commitment of the Latin American system with the standards that were listed by the special rapporteurship, they might bring some light to some decisions in other systems. For instance, environment is also an important case. Thank you.
Thank you for this valuable inputs. Now we move to Mr. Pushkar.
Yeah, I think it's just to pick up on what has been said actually by Daniele about the Inter-American Courts case law, and probably to switch a little bit to the side of the discussion on European Courts case law, as well to the topic of reparations. Actually, I think it's also probably to answer the question that we had before on how we can use the best practices coming from various systems in order to strengthen protection of human rights and the rule of law on horizontal level. I think what is interesting is that the Inter-American Courts case law is very much developed on the issue of reparations and remedies. There is a lot more suggested from this point of view in order to ensure that the states counteract impunity. And to answer this question, I think that we had, it's a very important question as to how the horizontal effect of the rule of law could be maintained and strengthened. I think one can say that the actions of private entities and private companies can contribute to better protection of human rights, and I think they can be engaged, and from a certain point of view they are already already entrusted with this engagement in ensuring human rights protection. So what I wish to say actually that and turn it into this discussion on the issue of reparations for the war of aggression is that we are actually witnessing the need for creation of public-private partnerships in enforcement of human rights through the principle and horizontal effect of the rule of law. And that's something that I think is extremely important in context of protection not only of individual rights, but of collective rights. So giving you an example that, for instance, the guiding documents on the right to reparation and remedy in international law, for instance, the UN Basic Principles of 2005 or 2011 guidelines on eradicating impunity for gross and serious human rights violations, they refer to a certain role of private actors in enforcing rights through this horizontal effect of rights, but also through horizontal action of rule of law. And in context of actually reparations for Ukraine, I think what is interesting to see in the Inter-American system, which can be borrowed for the construction of the future system of reparations, it is exactly this role of private actors, is the role of the victims and the concentration, the victim-centered approach, which is being applied to reparations more generally, the role of victim rights organizations, the role, so it's kind of the opposite. It's not only the corporate actors which are engaged, private corporate actors, which are engaged in enforcement of this horizontal effect, but it's also the victims rights organizations, the private entities which are engaged in this enforcement. And this is something which I think is extremely important to mention from the point of view of horizontal effect, just as this, as I said, private public partnership in enforcement of rights. I think it can be seen not only in the context of establishing what are the victims' needs for reparations, what kind of reparations can be offered through the action of private entities, but also as the UN basic guidelines on reparations, they suggest basically through dissemination of information about access to remedies through private actors, as well as through, as I said, this public-private partnership in enforcement of rights. So that's a discussion I wanted to suggest as well from the other side of spectrum.
Thank you very much. And then finally, Mr. Pogrebniak.
Ну, знову ж таки, я з великим задоволенням послухав моїх колег.
Again, it was very interesting to listen to my colleagues.
Єдине, що мені здається, можна було б
The one aspect which would be,
на
as from my side, be supplemented
дійсно цікавий досвід.
in addition to what was mentioned from different experiences from the respective
Мені здається, що можливо
systems, American and European. I think that possibly we could take into account an experience of the Court of Justice of the European Union, because actually this court had experience in implementation of a horizontal effect
прав людини
of human rights concept
діяльність, причому
and its activities, and
більш складна проблема, тому що вона
it's rather a more complicated issue because it is interrelated with the problem of the horizontal effect and the problematic nature of implementation of horizontal directives and other horizontal standards of the EU in the EU member states. And secondly, they have one more very relevant problem on implementation of General Human Rights Charter. So they have also interesting experiences which could be studied further and taken into account. In this regard, I think it will be relevant, but in any case, this is still a huge problem for many countries and for Ukraine as well, because Ukraine is on its path to the EU as a country candidate. So that would be one of the most important and interesting aspects in this regard for Ukraine. But in general, I would say that not only the experience of supranational court bodies, but the experience of national courts could be interesting here as well. And maybe for the future, it would be a good idea to supplement the problems we have discussed with the issues which are related to a difference of modes of implementation of human rights aspects in different levels of court system. So this experience might be interesting to different countries, and discussing it and exploring it could be beneficial for us too. But that would be maybe rather my wish for the future. Thank you.
Thank you very much. I would like to take the opportunity to thank everyone that has attended this event today, especially our distinguished guests and speakers, but also everyone who just contributed in being here and asking questions. Now, I know my colleague would like to say a few words about the other events that we have planned in this series. So I give the floor to Professor Uvarova. Thank you very much.
Yeah, thank you very much. And I also would like to say thank you to all our speakers and to all their ideas and insights that we heard today. And yeah, I just want to announce that we will have this Thursday, we will have the talk on sanctions, human rights sanctions against companies, and we try to bring together people with a very different perspective on this issue, very sensitive issue and important issue. So we will have scholars from constitutional law, from international law, and from business and human rights field, and also advisor of the UN Special Rapporteur on sanctions will join us as well. So please join us this Thursday. And the last talk will be about digital actors and the rule of law. And video recordings of our talks are available on the website. I shared in the chat. And also, I would like to recommend to hear our podcasts, because a lot of issues related to corporate actors and the rule of law were covered in the podcasts as well. And yes, thank you all of you again, and my special thanks to our great speakers and to our moderator today, Casper, and also to our interpreters. Thank you for your work, and see you on our next talks. Thank you.
Thanks, Alina.
Thank you very much. Thank you, Elena. Thank you, Stanislav. Thank you, Daniel.
Thank you,
Bye,
Pavlo. Thank you. It was
Mrs.
great
Gibson.
pleasure to see you.
Thank you very much. Likewise, yeah.